Sandy, could we begin by having you tell us what kinds of crises have brought about these styles of planning inherent in the concepts of arbitration and screening panels?
Professional medical liability has been a nationwide issue for several years, Steve. And in the bicentennial year, 1976, it was undoubtedly one of the most important dilemmas of our time, so to speak, and many legislators, doctors, and other people were quite concerned, including the public. The outlook for medical malpractice looks grim indeed, with medical liability insurance premiums escalating at approximately 22% per year and exceeding $2 billion in 1983. This phenomenal increase resulted to a great degree from a multiplying number of lawsuits and the large award settlements in individual claims. Now, except for Colorado, Georgia, Nebraska, and Oklahoma, the states are confronting two major problems with respect to medical liability, one being the availability and the second being the exorbitant premiums for medical liability insurance. For instance, high-risk category rates below $10,000 in some states are considered by some physicians as cheap. And in some cases, insurance rates have increased by 600%. Now, with the new government reimbursement system, including the diagnostic-related group payment structure, the practice of defensive medicine will be employed with more discretion and may even be cost-prohibitive.
With risk to physicians as high as you've implicated here, how are they protecting themselves?
Well, doctors have attempted numerous ways out of the malpractice mess, Steve. Some have gone bare, placing their assets in trust. Some have joined the military, where the hours of work are regular and no worries about liability premiums. Some doctors have moved from states with high premiums to other states with low premiums. And some doctors would rather fight and countersue. And some simply give up and go into early retirement.
What kind of consideration has the government given to the dilemma of the physician?
Congress has searched for various ways to alleviate the situation, Steve. The Alternative Medical Liability Practice Act of 1984, which was proposed by Gephardt and Moore, offers an inventive approach to no-fault system as an option to medical malpractice lawsuits. Now, under the Gephardt-Moore proposal, if physicians and hospitals offer a settlement to a patient within 6 months of alleged malpractice, court actions are barred. The patients would be compelled by law to accept the settlement offer for lost income and other monetary losses. Disputes on the dollar amount could, however, be litigated and resolved by a judicial review. But claims for mental suffering and other non-tangibles are also barred. Now, no doubt other innovative plans or methods for litigating or resolving the problems will be searched for. But this is to be looked at with a better approach. And what is the better approach? It is to try and lay a firm foundation of alternatives and solutions aimed at resolution of the agonizing saga, the doctor's dilemma of medical malpractice. Such a foundation of necessity requires that doctors acquaint themselves with the duty owed to their patients and to know about the various laws and that affect the practice of medicine, and to have a total commitment of all parties involved to search diligently for all the causes or etiologic factors of medicine or malpractice, and then proceed to map an all-inclusive regimen of therapy. And to accomplish this task, I think 5 things should be done, Steve. 1, we should educate doctors and the public about the problem. 2nd, we should have candid communication, an honest discourse, particularly between patients and doctors. 3rd, a sincere effort to avert litigation. 4, lucid and efforts that are at the federal and state level to alleviate the situation, and then to look for alternatives to litigation as the 5th method, such as arbitration and pretrial screening panels.
Sandy, let's pursue this arbitration term. It seems a very general one. Would you explain it specifically as it relates to being an option to litigation?
Yes. Arbitration may be simply defined as a method where parties to a dispute submit their dispute to a group that is impartial. This can be done by mutual consent or by statutory provisions. Now, there are 4 types of arbitration. One is compulsory, in which each malpractice dispute will be compelled to submit to arbitration. Second is the voluntary. Here, each malpractice dispute could be submitted to arbitration, but in contrast with compulsory arbitration, the right to jury trial is not lost, and this applies to both the plaintiff and the defendant. Next is binding arbitration, where the award is final and binding, both with respect to liability and damage determination. And finally, there is the non-binding arbitration. Here, the award is not final, and either the plaintiff or the defendant may elect to litigate the claim de novo, which is a situation that is costly both in time and money. So, as you can see, one can avoid litigation by submitting the claim to arbitration, and this can be accomplished either by a clause in the initial contract to the effect that a dispute will be arbitrated, or by a subsequent agreement to submit the dispute to arbitration.
Sandy, I expect that everyone has tried to resolve a disagreement at one time or another through arbitration or something like that. What is the history of arbitration, though, in our legal system?
The common law was originally hostile to arbitration. This origin of the hostility was a dictum by a Lord Coke, who wrote in the Villiers case back in 1609 that an agreement to arbitrate is revocable. From 1868 until 1889, the English Parliament adopted legislation permitting statutory relief for arbitration in England. In 1920, New York passed the first effective state arbitration statute, and in 1925, Congress followed with the U.S. Arbitration Act. Let me back off a little bit. In 1855, there was an English case, Scott versus Avery, which held that when submission to arbitration is a condition precedent to litigation, that would suffice to bar a lawsuit. On the other hand, it has been noted that agreements to submit future disputes to arbitration were held void as illegal condition to a party's bringing suit. And this has been cited in the case of M. Bernstein in private dispute settlements.
What advantage does arbitration have over litigation?
The advantages that arbitration has are several. They include rapid disposition of claims, of cases, selection of arbiters that are knowledgeable in the field, and also others who are legally sophisticated in medical law. Relaxation of certain exclusionary rules, thereby permitting hearsay statements and quotations from medical treatises. Also, there is likelihood that the exorbitant awards will be lessened, and also minimize publicity and decrease the overall caseload in the congested courts. Meany and co-authors concluded their discussion of alternative methods to litigation by stating that in the future, patients may be compensated on a no-fault basis, but in the interim, compulsory binding arbitration clauses should be included in medical insurance contract. Another author, Colson, believes that arbitration is simple and flexible. It is resorted to when other methods of litigation fail, and the same type of thing has been included or endorsed by, say, St. Paul Fire and Marine Insurance. They stated that arbitration is something to be included in their policy insurances.
Let's talk now about screening panels. What do we know about them? What varieties are there, and how do their tasks differ?
Screening panels, there are 5 major types, Steve. The first is physician screening panel. These are controlled by physicians. They are secretly operated generally, and their major purpose is to determine whether or not the claim alleging malpractice should be defended or settled. The second, physician advisory screening panels. These are primarily composed of physicians with some added representation by a lawyer, a clergyman, or a member of the profession in an advisory capacity. The third, medical legal screening panels. These are the most popular plans, and they may be regional or statewide. The panels are composed of members of medical and legal profession, and thereby providing more equal representation of the professions and broader understanding and objectivity with respect to resolution of the disputes. Court-sponsored screening panels is another type. These are administered under the court system, for example, in New York and New Jersey jurisdictions. And the last one is the statutory plan, and these are, of course, by law, and here the legislature institutes the screening panel.
Sandy, how much do we know about screening panels as compared to arbitration that we were talking about earlier?
Relative to arbitration, there has been little written about screening panels, for one thing, Steve, and they are newer concepts as compared to arbitration. Secondly, there is some hesitation to use screening panels because the panelists' decision is not binding. This situation is similar to non-binding arbitration. Now let me add a word of caution here when we are talking about panels versus arbitration. Confusion can arise when the term panel is used in a discussion of arbitration. Dornet, for example, lumps arbitration proceeding and pretrial screening panels as foremost among the methods used in attempting to reduce the cost of determining fault in medical malpractice disputes. Davidson, another author, expounds on arbitration and states that the American Arbitration Association would set up a three-man panel, he's talking about arbitration, consisting of a lawyer, a physician, and a person representing consumer interests. But despite the fact that the terms arbitration and panel are used loosely, nevertheless, they represent separate entities.
Earlier you touched upon the interest of the government in the discussion of the Alternative Liability Act of 1984. What statutory provisions have been made for arbitration and pretrial screening panels in medical malpractice claims?
The legislative response to medical malpractice problem has been overwhelming, an indication of the much needed remedial legislation in this area. Zimmerli and Bergen have reviewed some of the new proposals of legislative remedies in this area, including the bills in Congress and in the states of Indiana, Maryland, Michigan, North Carolina, Wisconsin, and New York and New Jersey. Bergen has stated that final and binding arbitration as an alternative to court litigation is a popular proposal these days, but that pretrial screening panels is controversial with no clear indication as to whether they are beneficial. The best and probably most equitable laws of arbitration in medical malpractice are exemplified by those of Michigan, which allow disputes to be presented to a three-man panel consisting of a lawyer, a doctor or hospital administrator, and a public person for final and binding resolution.
But are such laws relating to binding arbitration constitutional?
Well, the constitutionality has been challenged, of course, and they have been held constitutional in the recent Michigan case, Morris case. This case, the Morris case, a 1984 decision by the Michigan Supreme Court, was a culmination of several cases challenging the constitutionality and unconscionability of the Michigan Malpractice Act. Prior rulings by the Court of Appeals of Michigan produced decisions which at times favored and at times opposed the constitutionality. The primary concern of these cases, including the Morris case, was whether the three-man arbitration panel would be capable of rendering an unbiased opinion. The plaintiff argued that the panel with such a composition would hardly be objective, and this is because they would deny due process. But the court found otherwise. And the court also did not support the plaintiff's contention that the arbitration agreement was a contract of adhesion. Finally, the plaintiff argued that the arbitration agreement was unconscionable in that it forced that plaintiff to lose the trial by jury without recognizing the consequences of their action. Well, the court responded by stating that the agreement was in plain language and that any reasonable man reading the contract would assume upon signing the agreement that they had waived their right to jury trial. Thus, the constitutionality of the statute was upheld.
What about other states besides Michigan? Have they ruled on the constitutionality of binding arbitration?
Yes, Indiana has developed a similar law, and in Florida, where its medical malpractice law withstood the constitutional challenge in the Fifth Circuit, or in the case of Woods versus Holy Cross Hospital. Presently, there are 44 modern arbitration statutes in the United States which apply to present and future disputes. Common law applies where it applies to arbitration would deal with current disputes, not future disputes. Current legislation from 1975 till 1983 is available in about 14 states, which provides for arbitration in medical malpractice claims. These states are Alabama, Alaska, California, Georgia, Illinois, Louisiana, Maryland, Michigan, Ohio, Pennsylvania, South Dakota, Vermont, Virginia, and Puerto Rico. Other statutes have been amended in some states to include arbitration in medical malpractice, as in Minnesota and Wisconsin. And we would expect that other states may enact similar legislation, Steve.
What health care providers are covered or included under arbitration provisions?
Almost all healthcare providers are included under the arbitration laws, and they include chiropractors, clinics, dentists, physicians, health dispensaries, health facilities, health maintenance organizations, hospitals, nurses, nursing homes, optometrists, osteopaths, pharmacists, physical therapists, podiatrists, psychologists, and even sanatoria.
Sandy, I'm curious about the reaction of major associations like the American Medical Association, the American Osteopathic Association, American Hospital Association, and others in regard to the arbitration proposals.
In November 20, 1975, Steve, Dr. Sammons, then Executive Vice President of the American Medical Association, forwarded a memorandum to the executive directors of all state medical associations pertaining to the subject of arbitration survey. Dr. Sammons stated that arbitration is one of many tools that deserves further consideration for proposed medical liability solutions. He also stated that the AMA is cooperating with other agencies, including the American Arbitration Association, the American Bar Association, the American Osteopathic Association, the American Hospital Association, and other medical and insurance groups, and the Department of Health, Education, and Welfare, in an effort to monitor the experience of arbitration systems where they are in operation. The advantages of contract arbitration as viewed by the AMA and the American Hospital Association has been discussed previously, but the disadvantages include absent validity by most states of the arbitration, of binding arbitration, as to its efficaciousness. Also, the problem with adhesion contracts and problems with minors and deaths. Also, there is an adverse attitude by judges and attorneys toward contract arbitration. But the report of the AMA did not include the important legislation such as the New York Michigan, Massachusetts, Wisconsin, and others, Steve.
Well, perhaps you then, Sandy, could expound for us on arbitration precedents in New York, for example.
In New York, a compulsory malpractice mediation program was started in Manhattan in September 1971. That program was conceived by the New York County Manhattan Joint Interprofessional Committee of Doctors and Lawyers, and a panel system was developed with the cooperation of the Appellate Division of the Supreme Court. Every malpractice claim that New York had was to be mediated, the object being to relieve the overburdened courts and shorten the waiting period for malpractice trials, which can be as long as 5 years. The New York panels would review cases that are already in litigation, but the trial court has been given authority to exercise discretion in dispensing of cases which raise only basic factual issues that involve no complicated medical procedures. Such simple cases are considered within the ability of properly instructed juries to hear and fairly determine. But submitting these uncomplicated cases to arbitration panels that cannot make a final determination will only delay the trial. And this will add to the cost, too. New York's program represents voluntary, binding contractual arbitration. It is aimed at shortening the period of time to settle the disputes, decreasing the awards, eliminating the addendum clause or principle, permitting life structuring type of awards, and allowing penalties or for frivolous suits, and in many cases settlement may be had by a hospital malpractice grievance mechanism and not even go to arbitration.
And I'll bet the New York program has been challenged, hasn't it?
Yes, it has. The case of Halburn held that the New York arbitration statute was not an unconstitutional invasion of the province of the jury. The court applied the rational basis test of constitutionality, deciding, firstly, that the substantive right of the parties in a malpractice case is not removed by the new statute, since it does not deprive the litigant of the right or interest protected by a due process clause of either the state or the federal constitution. Secondly, the necessity for the new law is clearly established in that there is some fair and just and reasonable connection between it and the promotion of health, comfort, safety, and welfare of society. Thirdly, the legislature is free to experiment and to innovate, so long as it has any reasonable basis for its enactment. The New York statute was again challenged in another case, in the Allen case, where the appellate division reversed the lower court's decision that the statute was unconstitutional because it allowed the panel's decision to be admitted into evidence at a subsequent trial. The statute provides, if the 3 members of the panel concur about the question of liability, a formal written recommendation concerning such questions of liability shall be signed by the panel and forwarded to all parties. In such events, the recommendation shall be admissible in evidence at any subsequent trial upon the request of any party to the action. Now, the recommendation shall not be binding upon the jury, or in a case tried without a jury upon the trial court, but shall be accorded some weight as the jury or the trial court chooses to ascribe to it. If the recommendation is read to the jury or by the trial court, the doctor member or the attorney member of the panel, or both, may be called as witness by any party with reference to the recommendations of the panel only, and the party calling such witness or witnesses shall pay their reasonable fees and expenses. The court distinguished this statute from the Illinois statute on the grounds that while the Illinois statute allowed the panel's determination to serve as the sole basis of judgment in some cases, the New York statute only allowed the admission into evidence of unanimous findings of liability, thus preserving the jury's right to act as the final arbiter of fact. The court also determined that the panel's opinion if admitted into evidence at trial, was in essence an additional form of expert testimony or expert evidence. And using this characterization, the court was able to conclude that the legislature had merely amended the rules of evidence, an act which is clearly within the constitutional powers.
Tell us about the arbitration plans that California has developed.
California has developed some interesting law. Waterhouse, who is a defense attorney in Pasadena, California, reviewed the Ross-Luce program, which was instituted about 1929, which was a year after the enactment by the California legislature of an arbitration code which provided for arbitration of certain disputes where parties covenant to arbitrate. Waterhouse noted that compulsory arbitration was upheld by the California Supreme Court in a case from the Ross-Luce Clinic in 1935. He indicated further that the employer has a right to contract for the employee without the latter's signature, and the employee is bound to compulsory arbitration. Furthermore, he noted that the case of Doyle versus Gallucci, which is a 1962 case, established even more importantly the right to arbitrate, in that it specifically held that not only the employees could be bound by such a contract, but also his infant son. And the same applies to spouses as to children. In 1960s, a project was initiated by the California Medical Association and the California Hospital Association aimed at demonstrating in 10 hospitals the use of arbitration in a situation where one did not have a closed panel group as in the Ross-Luce plan, but rather a more common pattern of broad-based medical staff with different multi-specialties and different types of patients. In this plan or this group or type of arbitration, arbitration is voluntary and not compulsory.
And surely the constitutionality of the California plan has been challenged by now.
Yes, California arbitration plans have also been challenged as being unconstitutional. The case is the Terry versus Madden case. She underwent hysterectomy at the Kaiser Hospital in Los Angeles, and Terry's bladder was perforated during surgery, necessitating blood transfusions. She subsequently developed serum hepatitis and then brought suit against the hospital. By the way, her name is Terry Madden and not Terry versus Madden. The defendant hospital moved to compel arbitration pursuant to a contractual agreement between the plaintiff's employer and the Kaiser Health Plan. One of the plaintiff's contentions on appeal was that the arbitration contract violated her constitutional right to trial by jury. The trial court dismissed the plaintiff's contention, concluding that inasmuch as the parties to a civil action were capable of waiving a jury once the action was commenced, there was no constitutional limitation on their right to avoid jury trial by submitting their dispute to an arbitration group in the first instance. So the court looked to that as well as to generally limitation agreements, to arbitration agreements, and refused to interfere with these freely made contracts for fear of jeopardizing the legality of a vast number of functioning and efficacious agreements. A large portion of the Madden case revolved around the legal ability of the employer to bind the plaintiff under the arbitration agreement, and the court concluded that this was permissible, and hence the plaintiff's claim that the agreement was forced upon her and was therefore one of adhesion was negated. If the patient freely submits to an arbitration agreement, there will ordinarily be no disagreement as to going through with that agreement. And here the hospital and the employer entered into that agreement, and the court will find it that it is constitutional. Most most of the cases in California have upheld the constitutionality of arbitration, but the courts have continued to look closely at the material contained in the contract. And in one case they stated that the parties must be able to have the permission or be allowed to challenge the contract on grounds of coercion or misunderstanding.
Sandy, you've covered in detail for us now the changes in New York and in California concerning arbitration plans. What are some of the updates in screening panels for medical liability claims?
As of the end of 1981, some 25 states have passed laws dealing with screening panels for medical liability claims. The increase in legislative measures designed to combat the malpractice crisis also brought with it attempts to set aside legislative changes. These challenges are generally efforts of plaintiffs who are or believe they are adversely affected by the legislation. Although there have been challenges to arbitration in a number of jurisdictions, the statutes have fallen infrequently. In the case of Wright versus Central DuPage Hospital Association, the Illinois Act establishing mandatory medical review panels was struck down because it restricted the right to trial by jury, violated the provisions of the state constitution, vesting the entire judicial authority in the circuit courts, and was a special law in violation of the equal protection provisions of the state constitution. The court relied upon specific language of the state constitution to hold that allowing the lawyer and physician members to overrule the judicial member constituted an impermissible delegation of the judicial function to the members of the panel. In a decision, the court based its determination that the statute restricting the right to jury trial was unconstitutional under the separation of powers doctrine of the state constitution. However, the court made it clear that it was not implying that there could be no valid pre-trial panel procedure. Another interesting aspect of the case was the holding that the application of the maximum recovery limited in malpractice action was unconstitutional. This is unusual in that statutes prescribing specific statute of limitation applicable to medical malpractice have been upheld when challenged on equal protection grounds. The Massachusetts legislature responded to the malpractice crisis by enacting a law in 1975 which discouraged frivolous malpractice litigation by the creation of the pretrial screening procedure. The statute requires that all claims for medical malpractice with errors or mistakes to be presented to a judge, lawyer, and doctor for pre-screening. And then there is a determination of liability and for judicial inquiry. Or the plaintiff case could be an unfortunate medical result, which could be the decision. Here, the problems have arisen in applying this because the statute fails to clearly state the tribunal's role in the judicial process. This ambiguity becomes more apparent when claims before a panel concerned with non-medical issues, and it has been suggested that the panel be limited to reviewing issues of professional conduct of medical treatment only. In Wisconsin, the Academy of Trial Lawyers recently brought suit alleging the unconstitutionality of 1976 law, which established screening panels for malpractice claims. The Wisconsin lawyers contend that their clients no longer get a fair hearing from the panels and are therefore deprived of due process.
Sandy, what are the pros and cons of utilizing arbitration as a means for solving, at least in some part, the malpractice dilemma?
Arbitration is a method, not a panacea, which can be resorted to in an attempt to resolve the medical malpractice crisis. And that was said by Lerner, the Associate General Counsel of the American Arbitration Association. Lerner also warns that if arbitration is applied hastily without testing, it could be counterproductive and monitoring the results of 4 private contractual arbitration programs in Los Angeles, San Diego, Seattle, and Hawaii should be instructive. Another person who is an administrator had some interesting comments about the advantages and disadvantages of arbitration. He concluded, I think his name is Schneppel, and he concluded that the malpractice dilemma continues to be so partly because of the courts and the doctrine of charitable immunity, which had previously immunized hospitals, has been overturned. Also, there is expansion with the corporate negligence and the doctrine of respondit superior, as well as even res ipsa loquitur. Here the hospitals are experiencing a broad range of accountability. Schneppel stated that while arbitration may include some benefits such as cost saving plus increased speed, rationality, simplicity, certainty, it still retains the concepts of fault and the adversary relationship, which is inherent in litigation.
How do other people feel about this?
McMahon is more critical. He believes that arbitration is a technique that carries problems of its own, and it does not in and of itself address the long-term elements of medical malpractice. McMahon finds weaknesses specifically in the Kennedy-Inouye bill, which proposes a form of mandatory arbitration as a condition precedent to litigation. Karp, another author, claims that there is another problem and points out the possible effects on insurance claims, some of which are overly pessimistic, I might say. These include: arbitration may increase the number of claims made against hospitals and physicians. 2, arbitration of medical malpractice cases may result in greater lawsuits. 3rd, the lack of universality of arbitration may expose an insurance carrier to the double jeopardy for an arbitration hearing for one defendant and a trial for another in the same suit. Also, the finality of the arbitration or arbitrator's decision denies the patient's right to appeal. Next, he comments about encouraging claims because of the ease with which one can demand arbitration. Also, there is loss of jury sympathy, and there may be greater verdicts. There is, as far as he's concerned, no saving with respect to defense, and no protection for multiple hearings for the same issue, and also comments that the chances are cases will be more likely heard by plaintiffs' attorneys, because plaintiffs' attorneys are more than the defendants, and Karp feels apparently that plaintiff attorneys are not on the side of insurance companies. Also, he says arbitration contracts are a problem in that a physician who is forced to collect on the arbitration has to pay or post $150 in advance for each administrative request.
Sandy, tell us about the state of Indiana. I understand they have passed a law dealing with professional medical liability in 1975. Haven't the results they've seen there been fairly dramatic?
In 1975, Indiana did pass the law dealing with medical liability, which established a medical review panel to screen all claims. It permitted the panel's findings to be admitted as evidence in court and limited the physician's liability to $100,000. It also established a patient compensation fund with a ceiling of $500,000. It also excluded the addendum clause, set the statute of limitation at 2 years from the date of the act, and up to 8 years of age for a child. The results speak for themselves as to Indiana laws. 90% fewer malpractice claims have been filed in Indiana since the passage of the new law in 1975. To date, all claims and their results have been settled out of court with a top settlement of $100,000. I'm talking about the ones that have been settled. They've been settled out of court. And also, there has been only an increase in premium rates by 8% since 1975, compared with 100% increments per annum in 1973 and 1974 in Indiana. There are now many companies that write insurance in Indiana. 15 cover insurance for doctors and 14 for other coverage that is subsidiary. And the market is very good for the insurance companies and quite competitive. And finally, a number of physicians have come into Indiana allegedly due to the 1975 law and the healthy insurance climate.
As you've pointed out throughout our discussion, not every state is having the good fortune of Indiana. Perhaps in your concluding remarks you could sum up for us the current status of feeling toward these alternatives of arbitration and the screening panels.
Many jurisdictions are now struggling with the boundaries to be established in malpractice arbitration. Pennsylvania declared a section of its Malpractice Act unconstitutional in 1980. The Act had granted original exclusive and mandatory jurisdiction to an arbitration panel and over all malpractice negligence cases involving healthcare providers. A voluntary arbitration system resulted, which now requires the consent of all parties for arbitration. It can be seen, therefore, that while there is substantial optimism toward arbitration, there is also a resounding pessimism. The American Arbitration Association, the American Bar Association, American Hospital, and American Medical Association are cautiously, although clearly, moving in the direction of arbitration. Similarly, legislatures are convinced of the need of arbitration and screening panels as means to solve the malpractice problem. Arbitration and screening panels are not just ideas. Rather, they are things whose time has come. Time will tell the tale of the two tillers of malpractice soil, arbitration and screening panels. However, the operators of these tills must play a crucial steering role if the ideas seeded should give or germinate into anticipated fruits of labor. Arbitration and pretrial screening panels as alternatives to litigation in professional liability cases should be considered among other solutions. More and more states are recognizing the need for some form of arbitration and pretrial screening panel. However, it must be emphasized that not all malpractice cases lend themselves to one type of solution or another. This applies equally to both litigation and alternatives to litigation, and it is incumbent upon the medical community and the legal community to search continuously for different methods to solve the malpractice dilemma and to fashion proper and equitable solutions that are well enough to fit the intricate problems of our present-day society.